The detective looked me in the eye and said my father woke up and identified me as his killer. It was a total lie, but that legal deception cost me 17 years of my life. This is a quote from a real person who spent nearly 2 decades behind bars for a crime they didn't commit. We'll explore this case a bit later on, but first we need to establish an extremely terrifying and uncomfortable truth in America. Police officers are legally permitted to lie to you during interrogations. This isn't a conspiracy theory or an urban legend. It's an established legal precedent that has led to countless wrongful convictions across the United States. In 1969, the Supreme Court case, Frazier v. Cupp, established that police deception during interrogations is constitutional. The court affirmed the legality of deceptive interrogation tactics when police falsely told a suspect that his accomplice had already confessed and implicated him in a murder. The justices ruled that lying to suspects is simply a legitimate interrogation technique. This ruling has since been used throughout the country to sanction police deception in the interrogation room, making it almost always legal for officers to lie during questioning. Since then, law enforcement has used this power extensively, sometimes with devastating consequences for innocent people. Let me tell you about Marty Tankleff. On September 7, 1988, 17-year-old Marty woke up to find his parents brutally attacked in their Long Island home. His mother was dead, and his father was severely wounded. Marty called 911 immediately. Instead of allowing Marty to go to the hospital and be with his dying father, the police took Marty to the police station to interrogate him. During the interrogation, Detective James McCready told him something shocking. "Your father woke up and said, 'You did this.'" It was a complete lie. Marty's father never regained consciousness and would die weeks later. But the teenage Marty, grief-stricken and vulnerable, began to question his own memory. After hours of psychological pressure, he wondered if he had blacked out and actually committed the crime without remembering it. The detective helpfully suggested this theory, and eventually, Marty signed a confession that the detective had written. He recanted this confession immediately after learning his father had actually not woken up, as police claimed. Despite not one shred of physical evidence linking him to the crime, Marty was convicted and sentenced to 50 years to life in prison, based primarily on this false confession. He would spend 17 years behind bars before his conviction was finally overturned in December 2007 by an appellate court. Evidence had surfaced pointing to his father's business partner and others connected to his father's business dealings. Marty's case isn't an anomaly. It's part of a disturbing pattern. Take the case of 14-year-old Lorenzo Montoya from Denver. In 2000, when questioned about the murder of a teacher named Emily Johnson, detectives told Lorenzo they had physical evidence linking him to the crime: fingerprints, footprints, and witnesses who saw him. None of this was true. After hours of interrogation without a parent or attorney present, Lorenzo signed a confession. Like many juveniles who are especially vulnerable to these tactics, he would spend 14 years in prison before DNA evidence finally exonerated him in 2014. These aren't isolated incidents. According to the Innocence Project, approximately 29% of DNA exonerations involve false confessions. And in the majority of those cases, police deception played a critical role. Research has consistently shown that certain tactics like falsely claiming to have evidence are significant risk factors for false confessions and have contributed to some of the most notorious wrongful convictions in American history. So why do innocent people confess to crimes they didn't commit? The psychology behind false confessions is more straightforward than you might think. When placed under extreme psychological pressure, isolated from support systems, and confronted with what appears to be overwhelming evidence against them, many people, especially vulnerable populations like juveniles and those with mental disabilities, will confess simply to end the immediate stress of the interrogation. The Reid technique, developed in the 1950s and taught to hundreds of thousands of law enforcement agents across America, relies heavily on psychological manipulation. This highly confrontational method has been characterized by experts as manipulative by design. Officers are trained to claim they have evidence that doesn't exist, to minimize the severity of the crime, and to offer seemingly sympathetic understanding, all to extract a confession. We already know you did it. We have your fingerprints. We have witnesses. The only question is why you did it. These types of statements create what psychologists call an illusion of inevitability. When a suspect believes conviction is certain regardless of what they say, confessing often seems like the only rational choice, especially when officers suggest that cooperation might lead to leniency. The consequences of these tactics can be devastating. In 1978, Kevin Strickland, a black man in Kansas City, Missouri, was arrested for a triple homicide. Detectives told him that 2 other men had already confessed and implicated him as the shooter. This was a lie. While Strickland consistently maintained his innocence, he was convicted based primarily on the testimony of the sole surviving eyewitness, Cynthia Douglas. Douglas later tried multiple times to recant her testimony, saying she had been pressured by police to falsely identify Strickland. No physical evidence linked him to the crime, and 2 men who pleaded guilty to the murders insisted Strickland wasn't involved. Despite this, Strickland spent 43 years in prison, one of the longest wrongful incarcerations in American history, before finally being exonerated in November 2021, when a judge ruled that the evidence against him had been completely undermined. While Kevin sat in prison for crimes he didn't commit, the actual perpetrators remained free. This highlights another deadly consequence of police deception. When it leads to wrongful convictions, the real criminals remain on the streets, often committing more crimes. The Exonerated 5 case, formerly known as the Central Park 5, exemplifies this tragic reality. In 1989, 5 black and Latino teenagers, Yusef Salam, Kevin Richardson, Antron McCrae, Raymond Santana, and Corey Wise, were coerced into confessing to the brutal rape of a jogger in Central Park. During individual interrogations lasting between 14 and 30 hours, detectives told each teen that the others had implicated them. Under extreme psychological pressure, 4 of the 5 gave false confessions. Despite inconsistent stories that didn't match the crime scene evidence and no DNA linking them to the victim, all 5 were convicted and served between 6 and 13 years in prison. They were finally exonerated in 2002 when the actual perpetrator, Matias Reyes, confessed and DNA evidence confirmed his guilt. During the years these innocent teenagers spent in prison, Reyes had gone on to commit other violent crimes, including rape and murder. It's crucial to understand that these deceptive tactics don't just harm the wrongfully convicted, they undermine the entire justice system. When innocent people are imprisoned, public trust in law enforcement erodes. This is especially true in communities of color, which are disproportionately affected by wrongful convictions. So if the police can legally lie to you, what can you do to protect yourself? Legal experts unanimously recommend one critical step. Invoke your right to remain silent and request an attorney immediately. No exceptions. Remember, the Miranda warning states, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. These aren't just formalities, they're your constitutional protections against precisely these kinds of deceptive tactics. Even if you're completely innocent, speaking to police without an attorney present can have devastating consequences. As Supreme Court Justice Robert Jackson once wrote, "Any lawyer worth his salt will tell the suspect in no uncertain terms to make no statement to the police under any circumstances." While police deception during interrogations remains legal in most of the United States, the tide may be slowly turning. In 2021, Illinois became the first state to ban police from lying to minors during interrogations. Oregon and Utah quickly followed with similar legislation. By 2022, California and Delaware had passed comparable bills, and states like Colorado, New York, and others have been considering such reforms. These changes represent a recognition of the harm caused by deceptive interrogation tactics, especially to vulnerable populations. Juveniles are particularly susceptible to false confessions. Studies show they're 2 to 3 times more likely than adults to confess to crimes they didn't commit when faced with deceptive tactics. Meanwhile, 2 state Supreme Courts have found misrepresenting evidence to a suspect during interrogation to be coercive. Montana in 1979 and Hawaii in 2020. The damage is clear when we look more deeply at the case of the exonerated 5. Yusef Salaam, Corey Wise, Kevin Richardson, Raymond Santana, and Antron McCrae were between 14 and 16 years old when they were interrogated for up to 30 hours without lawyers consistently present. Police employed classic deceptive tactics, telling each isolated teen that the others had implicated them. Raymond Santana later explained how detectives convinced him that his freedom depended on placing himself at the crime scene and implicating others. This extreme psychological pressure on vulnerable teenagers produced false confessions from 4 of the 5, despite their stories contradicting each other and the physical evidence. Their wrongful convictions would cost them between 6 and 13 years of their lives and lead to lasting trauma. The human cost of these tactics extends beyond the wrongfully convicted to their families and communities. Husbands and wives lose partners. Children grow up without parents. Parents watch their children waste away behind bars for crimes they didn't commit. When Jeffrey Descovich was wrongfully convicted at age 16 of raping and murdering his classmate, based on a false confession obtained after hours of interrogation where police falsely told him he failed a polygraph test, his mother never stopped fighting for him. By the time DNA evidence exonerated him 16 years later, she had died, never seeing her son free again. Like in many such cases, Descovich's confession came only after hours of psychological pressure in an isolated environment where he was made to believe that confessing was his only path to ending the immediate stress of the interrogation. These stories represent just a fraction of the lives destroyed by a system that prioritizes confessions over truth. The question we must ask ourselves is whether a justice system that permits deliberate deception can truly deliver justice. For now, the most important thing to remember is this: regardless of your innocence, if you're ever questioned by police, exercise your right to remain silent and demand an attorney. It could be the difference between freedom and decades behind bars for a crime you didn't commit. Knowledge of your rights is your strongest protection against injustice. Use the following phrase without exception. Say your name, followed by, "I want an attorney, and I will answer no further questions."